Hi everyone, and welcome to Free to Use, a Google Hangout introduction for artists interested in finding, using, and remixing creative content. And we're going to be covering the ethics, the law, and your rights and responsibilities on this topic. My name is Philippa Pitts, and I'm the Crest Interpretive Fellow here at the Portland Art Museum. This Hangout is one of a series of workshops and online resources for the 2015 Mythos Challenge. The Mythos Challenge is a workshop series, game and story competition, and exhibition happening here at the Portland Art Museum this spring and summer. You can learn more about the Mythos Challenge at portlandartmuseum.org/Mythos Challenge. And today we have three fantastic panelists to introduce you to the basics of copyright, licensing, and the resources that are available to you. The first is Lydia Lauren. Lydia is a professor of law at Lewis and Clark Law School. Her specialty is copyright law, and she's also the president of the Oregon Volunteer Lawyers for the Arts, a nonprofit based in Portland that helps connect artists to the legal services that they need. The second is Jane Park. Jane has been with Creative Commons for 7 years, wearing a variety of hats in research, education, communications, and community engagement. She currently leads their platform initiative, which is focused on creating easy and enjoyable ways for creators to share and build on each other's works across platforms like Flickr, Vimeo, and the Internet Archive. Third is Ross Betzer. Ross is an information services librarian at the Multnomah County Library's Central Library. Ross works on lots of projects for the library, including research on copyright issues. But his favorite part of the job is helping people find the information that they need, in person, by email, or over the phone. So if you're watching us live, feel free to ask a question either on the Google Hangout Q&A app or in the comments of the YouTube stream. I'll be monitoring those as we go, and thanks to our Youth Council for the questions they shared in advance. So we'll be starting with those. So Lydia, I'm actually going to turn it over to you first to start defining some terms. What's copyright? What's public domain? What's fair use? Take us away.
Oh my goodness, those are a lot of big topics. So let's start with the first one. What's copyright? Copyright is the federal law that grants authors, the people who create original works of authorship, certain rights to control what happens to those works. So that's what copyright is. It's this set of legal entitlements that comes from federal law that's adopted by the United States Congress. Next one, I think you said, what's public domain? So public domain for copyright means works that are not subject to copyright protection. So it would be things that are very old. There's actually a clear cutoff for works that are published prior to 1923. Those are clearly in the public domain. There can be other works that are in the public domain that their copyright has expired. So that's a segment of what's in the public domain. Other aspects of what are in the public domain are aspects of works that are protected, but that are not, the particular aspects are not protected by copyright law. So for things like, take a hood ornament on a car. The hood ornament is protected by copyright if it's a sculptural work, like a little jaguar, for example. But the car itself would not be protected, and we would say that the car is in copyright's public domain. There might be some patents, might be some trademarks that we would have to worry about, but for copyright purposes, we would say the car is in the public domain. The other way that works can be in the public domain is if they're dedicated to the public domain. So somebody who creates something can decide to abandon their copyright by dedicating the work to the public domain. So that's what the public domain is. I think your last one was what's fair use. So we're going to spend, I think, some more time talking about fair use, but just a quick introduction of what fair use is. So I said that copyright is this bundle of rights that are given by the federal statute, the Copyright Act, but that bundle of rights has some limits on it. And one of those limits, one of those very important limits, is the fair use limit. And that says copyright owners, you have certain rights, but other people can actually use your work in certain ways that will not violate your copyright. We will call those certain ways fair uses. And so if something is a fair use of copyright, it's not an infringement of copyright. Determining whether something is a fair use or not, that's a little trickier. And I think we're going to maybe talk about that a little later on.
I think so. So you've covered a little bit of what determines whether something is protected by copyright. Are you feeling good about that one?
Well, I mean, I certainly can go into more detail. So when we talk about whether something is protected, right, I said it's for works of authorship. So in order for something to gain copyright protection, it has to have what we call originality. So it's got to have some aspect of the creator's own original take. The threshold for creative contribution that gives rise to a copyright is actually quite low. So a minimal amount of creativity is all that is needed. And it needs to, of course, also be something that's not copied from someone else. So if you merely copy someone else's stuff, you can't get a copyright in what you've copied. But if you add to that and you put your own stamp on it, then indeed that new creative content that you've contributed, that can be subject to copyright protection. The other aspect of copyright that's required under federal law is it's got to be fixed in a tangible medium of expression. Those are the words of the statute. So what does it mean to be fixed in a tangible medium of expression? It means painting it on canvas. It means typing it into a computer. It means drawing it on a piece of paper or fixing it in an MPEG file. Any of those kinds of ways in which we create content that other people can perceive, as opposed to the stuff that we create in our brain. We think about it, we can imagine it, that's great, that's wonderful, that's creative, but it's not subject to copyright protection until it's fixed in some other medium that other people can perceive it.
Fantastic. So let's say you are the copyright owner. What rights do you have?
So the statute gives you 5 broad rights: the right of reproduction, which means the right to reproduce the work in copies, and make other tangible objects that embody that creative expression; the right to distribute those copies to the public, so to sell them, to loan them, or to give them away; to publicly display them, so to put them in a museum or to put them on the internet; or for certain types of work, to publicly perform them. So for music and movies and that sort of thing, it means to perform them, to show them, to play them, to render them so that people can see them and experience them. And the last one is probably the one that we're going to talk more about, is the right to create derivative works. So I, as a copyright owner, have the right to create derivative works of my copyrighted work, which means I can take a book and turn it into a movie. But if I write a book and somebody else turns it into a movie without my permission, well, then they've infringed my derivative work right. So those are the rights, this bundle of 5 rights that are granted by the statute. But those rights are subject to limits, which includes the fair use limit.
Fantastic. And then I have one more question for you that kind of relates specifically to what the students are going to be using for the Mythos Challenge, which means, what's open source? What does that mean for software programs, etc.?
Right, and I think Jane's going to talk more about Creative Commons. Open source is a label that we use to indicate that some rights have been reserved, but that some rights have been given up to the public. So it's not a public domain dedication, it's not an abandonment of copyright, but it is an opening up of rights. So if there's software that's been released under an open source license, that generally means that not only can you see the source code, that's part of the requirement of open source, but that you're able to build on that software and make new stuff with that content, with using that software. That's a general, over very large, 10,000-foot view of what open source means.
Thank you so much, Lydia.
Sure.
And with those terms and background in mind, I'm going to throw out one of our most frequently asked questions, and this one's for you, Jane. What does all of that mean in the context of online? How, when, and even can you use images and content from the internet? So tell us a little bit about Creative Commons and your licenses and what you do.
Sure. So let me start with your first question about things you find on the internet. I don't think you should ever assume that anything you find on the internet is not copyrighted, because in the US at least, copyright is automatic at the instant of creation. So as Lydia mentioned, once you put something into a tangible medium, such as you write a blog post and you publish it, or even if you just write an email and you have it saved in a draft form, you are automatically granted all rights reserved copyright over that material if you are the owner of it. And so if you stumble across something on a website and there's a photo there and there's no copyright notice, you still have to assume that it's under copyright and it's owned by someone, unless otherwise indicated by that copyright owner. And so that's where Creative Commons comes in. Creative Commons, we're a nonprofit organization, and if I were to sum up in one sentence what we do as an organization, I would say that we make sharing online easier and clearer for creators to do. And so we give creators more options in how they can manage their copyright and flexibly share their works with other creators so that creators can build and tweak and remix on each other's works. So we do that through we develop a set of free copyright licenses that any copyright owner can use to indicate that they have given up some rights to their work, but that they have otherwise reserved copyright over it. So, for example, as Lydia mentioned, copyright covers a suite of rights: the right to publicly display, digitally distribute, and remix a work. So you would, in some cases, reserve the right to remix a work, but you would allow the public to digitally distribute it as much as you want them to distribute it. And so we have a suite of licenses that cover different kinds of permissions that you want to give to the public and different permissions that you might want to reserve. And those licenses are a total of 6 licenses, and then we also have 2 public domain tools, one of which called CC0, which you can use to dedicate your work to the public domain, and then the second tool is a public domain mark, which is mainly for use by institutions to mark works that have already fallen into the public domain, whose copyright has expired. So generally before, I believe it's 1923, Lydia can correct me if I'm wrong about that. And so that's kind of the suite of licenses we have, and I can show you our website and screen share the copyright symbols with you, or the Creative Commons license symbols with you a little bit later.
Okay, great. That's actually a great lead into our next question, which is, where are some reliable places on the internet or off to find things that are free to use? What's out there available for images, music, etc.? Jane, why don't you queue up your website, but I'll toss it to Ross first.
Okay.
Sure. So as far as online websites that are reliable sources, one thing I tell people is to always, sort of like Jane was saying, to always assume that stuff is copyrighted. You might want to always assume that a website's unreliable and investigate what the website is. So look for information about who made that website. Are they just some person? Do they even have a history? Or is it a group like Creative Commons who has a long history of doing this work that's non-profit? So you kind of have to evaluate each time you're looking at a website whether or not it is a good source. The library can certainly help you find that. I can show you on our website. Let's see. We've written something. If we say, let's say, copyright images, and I'm just searching on the library's main locallib.org website. And that, one of the results, the first one, is a blog post that I wrote called Picture This, Finding Free Images, Photos, and Clip Art on the Web. And I kind of explained in the blog, it's not like it's free, it's more like it's stuff that people have said you can use. And there's links here of some great websites to do that. And of course, you can always ask the library, and we're happy to find even more for you for the project you're working on. But maybe Jane can talk more about the first one on our list, which is the Creative Commons search.
Ross, I don't think we're seeing your slides.
You're not seeing it.
I've got a black screen. Oh, there we go.
Are you seeing it now?
Yep.
Okay. So yeah, so this is from the library's website.
Oh, you're gone again.
And I'm gone again.
There.
Now you can see it. That's strange. I have to be in Chrome or something. Anyway, so yes, we have a blog post with some great sites, but perhaps more useful is you can ask us, and we can give you a personalized list of what might be useful.
Do you want to toss that over to Jane now, or do you want to show us more from the library? Your choice, Ross.
Yeah, why don't you talk, Jane, about the Creative Commons search, because that's one of the first things I refer people to.
All right.
Sure. Can I actually go over the license symbols before I do that? Because I think those are the visual indicators for students and teachers to recognize that something is under a Creative Commons license. So yeah, so here, this screen, this is actually a slide from my SlideShare. And I think you can probably see the URL at the top left if you want to visit just SlideShare and download the slides yourself in the future. But so I mentioned that we have 6 Creative Commons copyright licenses, and essentially they're made up of these 4 elements. And when you mix and match these elements, they result in the 6 licenses. And the first element is attribution. All of our licenses have attribution, which means that you have to give credit to the copyright owner of the work. So if you see this attribution symbol, it means that you have to give proper credit when you are reusing a work, and they are reserving the right to attribution. The second element is share alike, and that means that if you make a derivative or adaptation based upon a photo or a blog post that you discover, then your derivative work has to be shared alike under the exact same license. The third element is non-commercial, which means that the copyright owner is reserving their commercial right to make money off of the work so that only they can sell the work. That means you as a user, if you stumble across a photo that has a non-commercial condition on it, you can't sell that image because that right has not been given to you. And then the fourth element is a no derivative works condition, which means that if you want to remix the work, create a derivative work based upon it, you would have to ask permission of the copyright owner because he or she has not granted that right to you. So those are the four conditions, and you can see that these icons, you've probably seen them around on different websites, and when they mix and match to form the licenses, this is what the license buttons look like. So this is also on our website, creativecommons.org/licenses, and you can see this is the license icon for CC BY, this is the license icon for CC BY ND, etc. And you can read more about different licenses and how they work on our website. I won't go into detail because you probably won't remember. You really have to kind of go through and read the description. But generally speaking, these are the buttons you'll find on websites to indicate to you that a work is under a Creative Commons license. Not all creators will add the button to their works. They will add sometimes just a textual notice saying this is under a Creative Commons attribution with a link to the license, and then you just click on the license, click on the license link, and it'll take you to this page, which kind of explains exactly what you can and can't do with the work. So that's basically how our Creative Commons licenses operate and look like. And I'm sure you've stumbled across them on the web, such as one major website that uses Creative Commons licenses is Wikipedia, which is the largest community-contributed encyclopedia in the world. So on Wikipedia, let's say if we search for let's toss out what article, what subject should we search for here?
Let's search for myth.
Myth, right. So we search for myth in the English Encyclopedia, and it takes us to the mythology article. So let's say you read this article and you want to translate this paragraph into Greek because you live in Greece and you want to make it available to your students in Greek. In order to do so, you'd have to scroll all the way down, and you can see right here it says text is available under a Creative Commons Attribution Share Alike license. What does that mean? It means you can translate it under certain conditions. So you click on that, and you can see here it tells you that you are free to share and to remix, to adapt the work, which means you can also translate it. But under the following conditions, you must attribute the work in the manner specified, and you must share alike your resulting derivative work. So you are free to translate it into Greek, but you have to give attribution to Wikipedia, and you have to license your Greek translation under the same exact CC BY SA license. So Wikipedia, all of the millions of articles on Wikipedia under Creative Commons. Another really popular site that I'm sure you're all aware of is Flickr. And what should we search for on Flickr?
Anyone else got an idea?
Wait, so I was searching for copyright.
Copyright? All right. Let's do that. So here you can see it results in all these images, but in order to search for Creative Commons licensed images only that you can use for free, you would click here under this license filter and you would click Creative Commons only. And then that would filter out the images that you can actually use. And if you wanted to further refine your search to, oh, I want to be able to use this work commercially, or I want to be able to make a remix of this photo, then you would click that. It would further filter out those images. And then let's say you click on one of these, you have this image here, and it takes you to the image, and here is a license that governs this image, and you can see it is the BY SA license, the same license that governs Wikipedia, which is Attribution Share Alike. So Flickr is another big platform that has CC licensed images. Another one I like to show people is whitehouse.gov. Not a lot of people think of whitehouse.gov as using CC licenses because generally speaking, all federal government created works are in the public domain automatically in the United States. However, they do contract third-party works a lot, and those works are not governed under the public domain. And so they have a copyright policy on whitehouse.gov where it defaults all third-party content under CC BY. So that's one neat thing to know. And then I'll finally show you CC Search, as mentioned previously. So Creative Commons Search is not a search engine itself, but it's a portal to all of the different sort of platforms and websites that have enabled CC license search and filters. So you can kind of search across different ones that you need. If you want to search Flickr, you would enter cats and then click on Flickr, and it takes you just directly to the Flickr site. So you can do it that way, or you can go directly to the Flickr site itself. And then there's other platforms here like Wikimedia Commons, which is the repository for Wikipedia articles, all of the images and media that illustrate Wikipedia articles. So yeah, those are a few places where you can find free CC licensed images and music and videos.
Fantastic. Thank you so much, Jane. That's a really rich set of resources. Ross, do you want to contribute any more from the library?
Well, sure. Do you want me to talk about not online sources too?
That'd be great.
Okay. So searching online, there's lots of ways you can find things, but one thing that Lydia was mentioning is that things that are published before 1923 are generally in the public domain. And so one way to look for images that you could use, or materials you could use, would be to try to find a book or a photo from earlier than that. And the library has many old things that have that sort of thing. I should have brought some examples of old books. And we also have books that gather clip art. And the idea with clip art is images that the publishers of these books have given you permission to use, sort of like Creative Commons works. So I have brought examples of that. So this one is, yeah, there we go, Ancient Mexican Designs. So Aztec calendars, gods, mythological characters. There's one on Greek and Roman designs. And a lot of these have CDs, so you can copy them to whatever you're working on. And here's one, it's a book of steampunk images. But with these, just like with the websites, you want to be careful and do a little bit of research about what kind of rights they're giving you. So on the website, like Jane was showing you, you look for the Creative Commons license or some other license if they're using a different one, and then see what they're giving you permission to do. If you're using a book of clip art, you can look at the very first pages, and there will usually be, along with copyright information, information about what you can do. Each of these books give you permission to use up to 10 images from the single book to basically do whatever you want. Another book, if you want to find more stuff in the public domain, one of my favorite books is this one from Nolo Trust. They do a lot of legal books for the average person. And this one's called The Public Domain. And it's all about the ways that things get in the public domain and how you can find them and how you can be sure that they are.
Fantastic. Those are some really great resources as well. And about how many of those clip art books do you have in the library?
Oh, we've got tons and tons. In fact, I'm going to try to do a better screen share this time. I want to vindicate my past attempt. Okay, are you seeing this?
Yep.
Okay, and now do you see, did it change?
Mm-hmm.
Fantastic. So we're on the library's website. If you search on there for the words just clip art, this is the main search box, you'll get results. And it looks like this gets 220 things. So yes, there's all sorts. Fantasy clip art, manga clip art, Christian clip art. So there's a whole bunch. And like I said before, you can always ask us. That's the best way to find something at the library. You can certainly do it yourself, and we've tried to make it as easy as possible, but we're always here to help you find what you need.
Great. And then what I would add to that from the museum side is that more and more museums are interested in placing their collections online, and many of them, there's a resource called Open Glam, which is an initiative that I'll actually ask Jane if she wants to talk a little bit more about as well, but where museums are interested in basically giving you access to their collection. And if you look online, specifically, we're linking to you from the portlandartmuseum.org/Mythos Challenge, our online toolkit will give you resources to find these museums. So institutions like the Brooklyn Museum, like the Getty, and in some cases like the Portland Art Museum, are offering you images that you're welcome to use to remix. They're things that are in the public domain that we can give you information about and access to many images, some of them high resolution, that you can use, get inspired, to learn more and to play. So one of my favorites is the Rijksmuseum, which is the National Museum in Amsterdam, which has an amazing collection of old masters art, which they really encourage you to remix. You know, if you have a favorite Vermeer, which is your favorite close-up crop, and do you want that specific crop that you've created? Do you want that remix that you've created on a book, on a mug? You know, really giving you the power to take over those images and how you want to use them. And that's the direction that museums are going in. So I encourage you to look around on museums' websites to see where you can find that information and those images as well. Jay, is there anything you'd add on that?
Sure. I just, since you mentioned it, here's the OpenGlab website. It's run by the Open Knowledge Foundation, and it does a really great job of keeping track of the different museums, libraries, archives, and galleries that have released images or artworks into the public domain or under Creative Commons licenses, digital versions of them, of course. If they're physical sculptures, they can't share that with the world in a physical way. And I can go over later whenever you're ready, you know, Brooklyn Museum examples, Rijksmuseum, etc.
Great. Do you want to show us like one particular favorite?
So let's see. I would kind of talk about the Brooklyn Museum a little bit, maybe.
Mm-hmm.
So the Brooklyn Museum, they're actually a great story because they have an online image collection of over 100,000 images of artworks. And when they first started to venture into the open space, they decided to release, in 2004, their images under the most restrictive Creative Commons license, which pretty much reserved all commercial rights and reserved any right to make remixes based on the photos. And that's because, you know, in 2004, Creative Commons had just been founded a few years earlier, and nobody really knew what would happen. And so they were afraid, but they wanted to still be open. And so they used the most restrictive license, and they got such delightful results and such support and notoriety from the community that they decided to go even more open in 2010 to getting rid of the no derivative works condition and letting their community remix the images. And then 4 years later, or 5 years later, because 2015 today, but I think they did this a year ago, they decided that they had such even more of a great experience, but they went to the most open license, which is Creative Commons Attribution. So that means if you visit their website today and you look at their online image collection, you can use any of those images and pretty much do anything you want with them, including remixing them. You can even sell them as long as you give credit to the Brooklyn Museum. So I think I have an example here of one. So here is an image of a decorative sauce boat, and you can see here that the CC BY license notice on the bottom, and you can download it and use it for free. So yeah, so that's Brooklyn Museum.
Great. So remixing and remaking images has come up a lot in looking at those clip art books and looking at museums collections and looking at Flickr images and Creative Commons licenses. I'd love to ask Lydia a little bit about the team's work. This is what they're going to be doing. What if they want to use images that are not in the public domain, that are not licensed under an appropriate Creative Commons license? Let's go into that fair use. What are the exemptions for things, I don't know, that are parodies or satire? How much do you have to change an image before it's considered to be a new image?
Yeah, so let's talk a little bit about fair use. So, you know, these resources are absolutely wonderful to find images that are in the public domain, old images that are, you know, published prior to 1923. You can do whatever you want with those. You find images that are Creative Commons licensed. You can do a lot with those. You need to understand the details of the license, and you need to make sure that you're complying, so that if it says no derivatives, you can't remix. But if it says CC BY, like the SUSBOAT example, you just need to make sure you give attribution, which is a really important requirement to be able to use CC licensed images. But even the CC licensed images acknowledge that there are fair uses that can be made. And if you're making a fair use of a CC licensed image, you don't even need to attribute. It's a good practice. It's a nice thing to do to acknowledge the artists that have come before you. But if you're in the realm of fair use, then actually you don't need to comply with any of these licenses. Now, being within the realm of fair use, what does that actually look like, right? So when we talk about fair use, the doctrine of fair use is actually codified in the statute. So there's a provision in federal law that says certain types of uses are not an infringement of copyright. In order to determine whether a use is not an infringement and is a fair use, the statute provides these 4 factors that courts are supposed to consider and weigh, and it makes it kind of hard to know whether a particular use is a fair use or not. So the things that the courts look at in this 4 factors are the purpose and character of the use, including whether the use is for commercial purposes. So when we talk about purpose and character, if all you're doing is reproducing something and, let's say, putting it on a t-shirt and selling it, well, then your use is wholesale copying, and it's for commercial purposes. It's to put it on a t-shirt and make money off of it. But if your use is taking an image and remixing it, adding your own creativity to it, adding other images to it, that use is considered one of the kinds of uses that copyright actually wants to encourage, not discourage. So that would be a use that would be a favored use under the fair use analysis. But there are still 3 more factors to consider. Whether there's prize money associated, that might cause a court to think it's commercial, but the court might look the other way and say, well, that's just prize money. You're not actually selling your work. The other factors are the nature of the copyrighted work. So what is this thing that you're copying? Is it a highly creative work, or is it something that's more factual in nature, more like a map, for example? Jane mentioned that all works of the United States government are in the public domain. That was one of the public domain things I forgot to mention in the opening. But maps that are created by the USGS, the United States Geological Service, those maps are all in the public domain. So if you want to use maps, that's a great place to get maps. So that's the second factor. The next factor is, how much of it did you use, right? So it's the amount and substantiality of the portion you used. Did you use the whole image, or did you just use a part of the image? Was it, the entire 3-minute song, or was it just 20 seconds of that 3-minute song? Those are the kinds of things the court looks at under the third factor. The fourth factor is the effect of the use on the market for or value of the copyrighted work. How much is this use that you're engaged in going to interfere with the copyright owner's market? Because copyright is actually a lot about money. It's about allowing creative individuals and then the people who publish those creative works to make money off their works. And so if your use is going to get in the way of that money transaction, a lot of times what I tell my students is, it's all about the money. It's all about the dollar sign. So let me show you some examples. I'm gonna screen share some slides of some cases where we have some fair use rulings. So the first case is a case called Prince versus Cariou, and it's a ruling from the Second Circuit, which is sort of the East Coast, New York, that area, from 2013. So it's not that long ago. It's a pretty recent case. The images of the 3 individuals over here on what I think is going to be the right side of your screen, those 3 portrait images were the plaintiff copyright owner's works. The defendant had taken those and had put them into this collage that you see on the left side of your screen. The court ruled that that collage was a fair use as a matter of law. So there didn't have to be a trial. That was a decision that could be made earlier on in the litigation, and it was a nice, in some ways, bright line rule. That kind of use is a fair use. And you can see the images of the copyright owner are used, but they've been modified quite significantly. They've been combined with not only images from the copyright owner, right, these 3 portraits, but also other images, right? So you've got a mixing and a matching. Now, in that same case, there was another set of images. Again, the copyright owner's work on the right and the defendant's work on the left. The defendant's work in that instance, the court said it could not rule as a matter of law that that was fair use. So instead, that case had to keep going. Ultimately, the case settled. There wasn't a trial. So for the images that the court said were not necessarily fair use, we don't, in the end, get a ruling on whether or not they were fair use. And the court talks a lot about the minimal additional creativity by the defendant. You know, all they did was add these 3 circles and add in this image of the guitar and the large hands. So there's an example in one case of certain images held to be fair use, certain remixes held to be, well, not infringement, but not fair use. In other words, the case wasn't over yet. Let me show you an example from the Ninth Circuit, which is the court that covers Oregon and California and Washington, sort of the West Coast court. This is the case of Seltzer versus Green Day. Again, the copyright owner's image is on the right here, and the defendant had used that image and had added color, added a large cross. It was used as a backdrop for Green Day for one of their concert tours. Again, in that case, the court said that kind of remixing and that kind of use was fair use as a matter of law. So you can see the significant additional creativity that was added by the defendant. I'm going to show you one last one, and it's a case from a little while ago. This is the plaintiff's copyrighted work. It was used as an advertisement for shoes. And what the defendant, Jeff Koons, a famous artist, did was he took that image of shoes and he added it with some other images of feet and another pair of shoes. And the way you have to sort of think about it is you have to take that ad and turn it sideways, turn it upside down, and add it into the poster. And the court in that case said that use of that image of those shoes mixed in with everything else and the donuts and the pie that's in the background, that was a fair use as a matter of law. So we do have some case law out there that's quite favorable for remix, at least in the visual image space. And I thought it would be helpful to show you some of those examples while also talking about the 4 factors that courts consider. So hopefully that was helpful.
I have a question for Lydia, if that's okay.
Sure, absolutely.
So in those court cases, and especially the last one with the shoes, how do you have any knowledge of why the court ruled that fair use was as a matter of law, like the transformative factor, the purpose and character of the derivative work?
Yeah, so absolutely, there's a notion that transformative use, as Jane said, is a really important criteria when we're evaluating fair use. So the defendant transformed the plaintiff's copyrighted work. Right? Only a portion of the image was used, just the shoes, not it's actually a man's leg that the shoes are resting on, right? That got cropped out. So there was a transformation of the image itself, a transformation by the addition of all those other images that helped the court say the purpose of this use, that first factor, the purpose of the use by the defendant was something completely different from what the copyright owner was trying to do with their work. Their work was an advertisement. Right? It's a really different kind of work that the defendant had created from the photograph for an advertisement that the plaintiff had created. Also important in that case was the effect on the market. So the market for the reuse of that image of the shoes would be for other advertisements, perhaps other uses of that image, but not a remix use market. So the court really indicated, as far as markets are concerned, that use by the defendant didn't harm the traditional customary markets that the plaintiff of those kinds of images, those kinds of photographers, right, would have. The market being the advertising market. Does that help?
Yes. No. Yeah. That's. I think that's a great point.
Great. Thanks for the follow-up question.
Thank you so much, Lydia. I think that was enormously helpful. So we've kind of covered a lot of different ways in which Mythos Challenge entrants or artists in general could be creating images. They could be using images under Creative Commons licenses. They could be remixing under fair use. What rights do these students then have to the works that they've created, and what determines that? Jane, do you want to start on that with what they could do in terms of Creative Commons, and then I'll toss it to Lydia?
Sure. So as we showed you previously, if you stumble upon an image or other kind of artwork under Creative Commons license and it allows derivative works, so it doesn't have the no derivative works condition on it, that means you're free to remix it, translate it, adapt it, as long as you follow the conditions of the license. So that's attribution for all Creative Commons licenses. And if they reserve, they have the non-commercial condition, that means you can't make money off of your work, but you can still remix it. If they have the share-alike condition, that means if you make a remix, you have to share your own remix under the same exact license.
And Lydia, what would you add to that?
Sure. So when you create something, right, your own creative expression, and you've embodied it in some tangible medium, so maybe it's a video, maybe it's a painting, you get a copyright immediately. As soon as it's fixed, you have a copyright under federal law. You might decide that you want to register that copyright. That's something that you can choose to do if you want. The Copyright Office has some tutorials about how to go about making a registration, and you can do that. There are advantages to registering. You don't have to register, but if you do, you get better remedies if you ever have to enforce your rights, which can help a lot. And those rights are yours, and you get to decide what you want to do with them. One option is to release it under a CC license. And if you do that, you're saying, look, I want to keep certain of my rights, but I want people to feel free to do certain things with my work. I want people to feel free to distribute this. I want people to feel free to remix from what I've made. And those are choices that you get to make as an author. You get to decide, how do you want your work to be out there in the world? Do you want to keep it for you and you alone to decide, or do you want to upfront say, some uses are fine with me? And that's the wonderful thing about the Creative Commons license tools, is they really do put power in your hands to make decisions about how you want your work to be distributed.
Fantastic. So inherent in that is kind of this question of attribution that keeps coming up. You know, how do you credit an artist? How do you attribute it to them? How, when, and why should Mythos Challenge entrants acknowledge the creators of the works that they're remixing? And this is kind of a question I'd love to hear everyone's input on. Who would like to take it first?
Well, I'm happy to sort of give my take on how, when, and where. So if you're doing a video, that kind of thing, the when would be in the screen roll, right, in the credits that roll, and you sort of attribute all the different works that you've used. So that's the when or the where. The why is, well, number one, as a matter of copyright law, you might have to, right? So if you're relying on the Creative Commons license, you have to use that attribution. You have to do that in order to stay within the boundary of the licensed rights that are granted under a Creative Commons license. There's another reason to do it, not just legally you're required to. But the other reason is to acknowledge the creators that came before you, just like you'd like to be acknowledged when somebody might copy from what you've done. Maybe you want them to copy, but you'd like to be acknowledged as the creator of that work. So there's an ethical component to that, and a sort of, play nice component.
Ross, what do you think?
Yeah, I mean, I think Lydia covered the main points. I mean, one aspect is that the reason that those people in those examples she showed of people getting lawsuits against them for uses of works that they were doing, those happened because someone whose work they used was upset about it for one reason or another. And so it's kind of in your best interest to keep the creators of the works happy that you're using and you're benefiting from the art they've made, and giving them permission's a way to do that, or giving them credit's a way to do that. I was going to bring up that one way you can use things if something doesn't have a license, like a Creative Commons license, or if you're not sure whether it would be fair use, you could always just ask the artist for permission. That's something the library does a lot. We did a recent online collection of photos of the library and of activities at the library, and some of those photos we put into our online collection were ones that were old enough that they probably weren't protected by copyright. Others were ones that we took ourselves, or staff working for the library took. But then others were ones where we got in touch with the photographer or the photographer's children and asked them for permission. And they were happy to give it to us because they liked the library. We explained the purpose of why we were doing it and what we were hoping to do it for. So that's something that the Mythos participants, I mean, as a last resort, they could always just go to the artist if there's a way to contact them. They would want to make sure they kept, Lydia can probably correct me if I'm saying anything wrong, but it would probably be a good idea to keep a record of that permission that you got from the person.
Yeah, and just doing that by email is fine, and keep the emails, right? So you know you had permission. And that's actually, Ross, that's a great point. You know, a lot of the lawsuits happen when people are upset, right? So if you behave reasonably and you are accommodating to what it is the artist that came before you want, you can avoid a lot of trouble.
Great point. Jane, anything from your perspective over at Creative Commons on attribution or asking for permission?
Yeah, even with Creative Commons licenses, for example, if you stumble across a work that's under the most restrictive license that doesn't allow derivative works, but you want to make a remix of that image, just like Ross said, you can still ask for permission from their author directly saying, you know, I know you have this license that prohibits derivative works, but can I still make a derivative work for this purpose because I'm, you know, a teacher, I'm a student, and, you know, it may be very likely that they'll say yes, and they'll give you permissions beyond the scope of the license. In terms of attributing CC licensed works as a matter of practical use, we actually have a page on our wiki, Best Practices for Attribution, which has examples by medium. So if you are giving attribution to an author of a photo, we have an example, an ideal attribution example of that. And then we have examples by video and other kinds of, and for text. And generally speaking, and we use this acronym with elementary school aged students as well, and it works well because it's easy to remember. We use the acronym TASL, T-A-S-L, which stands for Title, Author, Source, License. So we all know what the title is. With the title of the work, you'd want to retain, you want to name the author of the work. The source nowadays is usually the original web page where you found the work, and then the license. You want to retain the license notice, so whatever license the image was under, the CC license, you would want to provide a link to that license. So yeah, we have that page, and you can take a look at it. It has examples of attribution that you can just kind of copy and paste for your own attributions.
It's funny because it's actually a little bit the same in the museum world. When you're on an online collections page, and I'm actually going to hop us on over to the Florida Art Museum's online collections. As you can see here, what we have is actually almost like a citation right there in online collections. And if you're going to cite a work from a museum, those are the best ways to cite it because it's a little series of numbers at the end. Here it's 328929 is an incredibly important piece of information for museums. It's sort of like our ID number. And it's what people can use to find that work of art. So if you were searching in online collections, that's how you'd know you get back to the record. And that's the record that we keep consistent through everything. So that's the number our curators use. That's the number the people who install the works use. It's so that we know exactly which work you're talking about. Kind of like a library barcode or the way they catalog things over there. And that kind of brings me to what I would sort of add to this moral component of attribution. It's, you know, both giving credit to somebody, and it's also saying that, you know, let's say somebody loves what you made, they love the image that you used. It's so frustrating when you're online and you find something really compelling and you have no way to get any more information about it. How is that person supposed to then investigate more, find more works? It's one of my biggest sort of problems on the internet is being able to find out more, and that's what, you know, especially when you're using these images and you're creating things for educational purposes or to share a story that's really compelling to you, why would you kind of cut the legs off for other people to dig deeper and learn more into what you've been doing? Any further thoughts on attribution from anybody?
Just building on what you said, Philippa, that's actually one thing we're exploring. So on platforms like Flickr and Wikimedia Commons and YouTube and Vimeo, how can we do a better job of connecting Creative Commons creators to each other and to their users so that they can express gratitude for each other's works, but also, you know, learn more about each other as creators and really connect to the community. So that's something we're focusing on this year as part of our Creative Commons strategy.
That sounds really fantastic. And on a practical note, just sort of thinking about platforms and how we're doing this, we know that as Mythos Challenge entrants, you're looking at a number of different ways that you could be creating. It could be an app, it could be a digital game. You can definitely create source pages and citation pages and reference pages. You know, it doesn't necessarily have to be on your artwork right there, just as long as somebody can trace back through the way it works. And Lydia can correct me if I'm wrong on that.
No, it's very helpful to have that sort of ability to trace back. I think, you know, the moral component has two sides to it, right? It's the moral, ethical attribution, acknowledging the creativity that came before, but then the sort of the obligation to let people know, if you like this, how to find it. So it goes both ways.
All right, so we're coming up on the last 10 minutes of our hangout. I'd love to ask everybody what is the one thing that they think will be the most helpful for people to know about copyright, about resources when they're building these projects. Jane, can I toss that to you first?
Sure. I guess one thing is to just not be deterred by anything you find. If you really want to use it, there's always going to be a way that you can contact or track down the copyright owner. And even if it's something's under the most restrictive conditions, when you have a conversation with them, you can always mention, and it's an educational opportunity to say, hey, there are these Creative Commons licenses. Would you consider licensing your work under one of them so that I can use it, and so that other educators and other students can use it for the same purpose?
Fantastic. Lydia?
Well, so the Oregon Volunteer Lawyers for the Arts is there to help creative people who need help with legal issues that they encounter. I'm not sure if that would be good for the timing of how these students are going to be creating these projects, but I do want people to know about that resource out there. And, you know, like Jane said, don't be deterred. You know, create fearlessly. That's what you want to be able to do. Don't let copyright get in the way of your creativity. Engage in that creative work. And then, if you need to sort of go back and figure out the clearances, okay, deal with that when you have to. But really, you know, embrace your own creativity and have fun with it.
Ross?
I guess the one thing I would say, just to add to that, Jane and Lydia said it really well, is I think it's good for people to remember that copyright's not a black and white thing. It's not like a speed limit where, oh, you're speeding, you're not speeding. And so don't be too scared, but also take the opportunity to learn something about it. There's lots of great places you can read about copyright online. Looking for university websites, pages about copyright is a great thing to do. They have lots of things for students about it. Reading a book about it is great. Or asking at the library, we can help you find information about it too.
And if I had to think one, it would be just kind of to look broadly. We've introduced just a few places that you could find great resources that are available, but the more you dig, the more you find. And I love that idea of, you know, remixing, appropriating, exploring, and thinking about these things ethically and, you know, responsibly, but as opportunities to engage with things that you may never have known that you didn't know. And there are so many resources, and you'll just stumble across so much great content on your way through. So kind of take it as an opportunity to, as Lydia was saying, create fearlessly. I'd love to throw out a couple questions that we've had from our youth council. The first one is, can you take a photo of art as long as you cite the artist? And I know that in particular they were interested in the White Stag sign and the Portlandia statue and things that they've heard some copyright rumors about. Lydia, do you know anything about that?
Sure. Well, so in those instances, you would be in fair use land because those are examples of artwork that are not Creative Commons licensed. The White Stag sign, you know, I don't know its history. I'm not sure how old it is. You know, maybe it's actually in the public domain. If it was published, you know, out there before 1923, I don't even know if it's got a copyright notice on it, which we no longer require, but we used to require. So there's some haziness surrounding the White Stag building, at least in my mind. I don't know the details of that. The Portlandia sculpture, that's one that the artist has been quite assertive with his rights, and so you'd be in fair use land. You'd need to be, you know, remixing and reusing in a way. Taking the picture and merely attributing the author doesn't get you out from underneath copyright law, unless you've got a CC BY licensed work, and then you're complying with the license by giving the attribution. But without that CC license, just because it's out in the public doesn't mean you can just take a picture and do whatever you want with it. You can take a picture and you can do fair use things with that picture.
That's a fantastic answer. Jane or Ross, would you add anything to that?
No, I would say I'm not a lawyer, so I can't give you legal advice about that. However, you should learn more about fair use and copyright of photos, which I can't help you with.
I will say that there was that ruling, it was Bridgman versus Corelli, where if you make a faithful kind of photographic reproduction of a work that's already in the public domain, then that photo is also considered in the public domain. So a lot of museums or institutions will put up photos of public domain works, and when there's no kind of creative element involved there, you can assume that the photo, if you're accessing it within the United States, is also in the public domain.
That's absolutely true. Another case that I would mention is there's a case involving a beautiful sculpture. It's a Korean War veterans memorial in Washington, D.C. Photographer took a beautiful picture in the snow. These are sculptures, life-size sculptures of soldiers with big coats on, and the snow had fallen, and he took a picture. It was a gorgeous picture. The U.S. Postal Service decided to make a stamp out of the photograph, and they got permission from the photographer, but they didn't get permission from the underlying sculptor. And the underlying sculptor sued, and the court said that was an infringement. Now, that's a pretty commercial use, using that image as a stamp, and it was just that image, so there wasn't a collage going on or anything like that. So you need to be careful with that, but you are in fair use land.
That's great to know, because that means that if you visited a museum or you were walking down the street and you took photographs, you need to be aware of whether or not the sculptor, like the Portlandia sculpture, is maintaining their copyright. But knowing that if you find something that you know is in the public domain, including a lot of works in art museums, would you then be in the clear if you took a picture of a public domain old master painting in a museum? Would you be fair to go with your picture, Lydia?
Certainly. If you took the picture, you've got no concerns whatsoever. Jane's point was, in addition, if you find an image, a picture of a public domain work in the United States, you also have no problem, because that image that is a faithful reproduction of a public domain work doesn't have another layer of copyright that you need to worry about. So public domain old stuff, oh yeah, go ahead with the old stuff.
Fantastic. All right, our last question. If someone copies something unintentionally or doesn't cite it and then they remove it, can they still get in trouble for it later? Lydia, you're up.
Yeah, well, so the sad part is, yes, sometimes you still can get in trouble, but I keep saying fair use, because that is, in fact, where you would land. Copyright, it doesn't have an intent requirement to infringe. You merely infringe. We don't care why you infringe. We don't ask about, did you know you were infringing? That's not a part of the law, unfortunately. So, in fact, if you reproduce the thing, this copyrighted thing, and you found out later, oops, I didn't mean to do that, and you take it out, that actually bodes very well for a fair use argument, but it doesn't make it a slam dunk, you have no problems. So, yeah, there's some risk there, but, be reasonable, and in general, things tend to work out. But the sort of hardcore law answer, yeah, there's still a risk there.
Okay, so we've been here for about an hour. I wanted to thank Jane, Lydia, and Ross for so many great resources and ideas, and it feels like there is so much content out there that is available for use, for remix, and thank you so much for sharing your expertise with us. That's the end of our time. If you have any more questions, please feel free to reach out to us. As I said, you can find out more about the Mythos Challenge and online resources at portlandartmuseum.org/Mythos Challenge. And thank you for watching. Take care.
Thanks.
Thanks, Felipe.